When negotiations come to an impasse, I often use a simple but very effective tool to break through the block. It's every parent's nightmare when heard over and over again. The simple question, why? When the other party is adamant about a transaction term to which, for its own reasons, my client cannot agree, I typically ask the other side why that particular deal term is required. I ask the question in order to understand the reasoning behind their requirement and to then share with them the reasoning behind ours. Only in this manner can the parties begin to fashion a resolution to the impasse that substantially satisfies the needs of both parties. Let me give an example. I had a negotiation with counsel over the terms of my client's form of manufacturing agreement, which I incidentally drafted. At one point he told me, "I cannot recommend my client sign the agreement without an express indemnity provision in my client's favor." By the way, this is the way lawyers politely tell each other to go pound sand. When asked why he needed that provision, however, he of course told me that he needed to ensure that number one, my client stood behind its products, and number two, my client would cover his client's damages that result from my client's products. I floored him when I went overboard to tell him that I wholeheartedly agreed and would advise my client the same in the reverse situation. I then told him I still could not give the express indemnity due to the insurance company requirements for my client's breach of contract insurance coverage. I then suggested that since he had already approved the other contract obligations of my client, including scope and quality of work, regulatory compliance, and limited warranty, that we consider adding one additional contract provision, that my client maintain and continue to maintain specified levels of insurance to cover product liability, breach of contract, and breach of warranty on the part of my client, and that his client would be named as an additional insured under those policies. It was something I knew I could do. He agreed that any significant damage his client would incur would arise from those types of claims and accepted the proposed resolution to this contract impasse without the indemnity. Each party's very reasonable transaction needs were satisfied with a rather simple workaround, once all needs were known and understood. So why? A simple word and powerful negotiating tool.